Let's get down to some practical legal writing skills. Write. This is the approach students sometimes take to papers, exams, and any written work they turn in. They will come to see their prof and ask why their mark was so low. Their defense is that, "It was all in there. I made that point." Yes, but if you made it in a disorganized fashion, you won't get full marks. You need to put like things with like, and tell your reader which items are more important than others. You can't just throw it all on the page and tell your professor it's all there somewhere. The process in this submodule assumes that you have done your research and you are now ready to get down to writing. There are 3 main steps to good legal writing: plan, write, and the most important one, revise. So, let's talk about planning. Think about these things as you plan. Who's your reader? Is it a prof, an articling principal, or maybe just a random lawyer who's hired you to do some contract research? It will make a difference how you approach your memorandum depending on who your audience is. Think about the purpose of your memo. Is it a course requirement? Is it for a case file? Is it to assist a professor doing academic research? Gather the information once you've determined your reader and your purpose. Put it together and organize it, I suggest, into secondary and primary sources to begin with. Then you're going to get down to analyzing it. Analysis and synthesis of the information is the subject of the next submodule. Outline your memo using your old friend, FILAC. Now for the good part. Here are some common student misconceptions about their own writing. If I use long sentences and lots of big words, I win. This is wrong. More is better. Less is dangerous. This idea comes out of insecurity about your ideas. In legal writing, less is always more. My prof is cool, so I'll just throw in a few little colloquialisms, use some casual writing. Don't do that. Your prof is still your prof. People express themselves more casually when speaking than they do when writing. If casual writing's a no-no, then I have to use lots of big and ancient wordy type things in order to succeed. Please, use the plainest language that gets the point across. I have fallen in love with certain words such as however, moreover, insofar as, regardless, and I shall use them again and again. I am begging you not to do that. And finally, punctuation is irrelevant. As I like to say, you are always just one misplaced punctuation mark away from being misunderstood. Take a moment to read this. Another common example is, let's eat, no comma, grandpa, meaning let's eat grandpa, or let's eat, comma, grandpa, which means let's have dinner together. But first drafts are your opportunity to get everything down at once. Although I'm asking you to edit your work carefully, don't start that editing process right away. Get it all down on paper first, and then use your time to edit carefully. Yes, let it go, as they say in Frozen. Don't overthink as you start your first draft. It's really hard to go back and recapture ideas if you don't get them out in the first place. So use that first draft to just get the meat of your ideas out there, and then the process, the very important process of revision begins. So, organize your draft once you have your first draft done using facts, issues, law, analysis, and communication/conclusions. Now, while you're organizing, use headings. Phylac gives you some nice ones to start with. Maureen Fitzgerald, in her excellent book, gives you some ideas for subheadings. But whatever you do, do not hand in a big, long bag of words and expect to get a good mark. Legal readers are in a hurry most of the time. They expect to be able to skim your work using your headings to get the idea of your memo before they focus in on specific parts of it. This is my least favorite part, but it is essential. You have to be objectively critical of your own work if you want to succeed. Check it for all of the characteristics of good writing that we're talking about in this unit before you hand it in. There's really not much use in doing it afterwards. We all fall in love with the sound of our own phrases, but good legal writing should be transparent. It should be so good that the reader is not distracted by the writing itself and can see right into the meaning of the work. American novelist and essayist George Orwell was passionate about good writing. Here are his most important rules for writing well. Clarity. If you can cut a word out, cut it. Brevity. Don't use a long word where a short one will do. Readability. Don't use the passive voice if you can use the active voice. If you don't know the difference between passive voice and active voice, talk to your TAs or your ILS instructor, but you really need to get a handle on that. Accessibility. Use plain English unless there is a term of art that says it more succinctly and you know that that term of art is going to be one that's understood universally. Before you hand anything in to me or any other professor, check for these things. Content. Did you answer the question that you were asked? Organization. Does your work have headings? Is it organized into neat paragraphs? Have you used proper punctuation? Are your sentences clear, or are they too long and wordy? Have you used good words, meaning have you used the simplest possible word to get your idea across? Are your headings useful? Do they draw the reader in? Do they invite the reader to the conclusions that you're leading to? Are your conclusions succinct and accurate? I'd like you to start by taking a look at the sentence on the left-hand side of this page. The lesson to be had from this PowerPoint by Professor Maur is that it is possible for students to accomplish a more accessible writing style with some attention to self-analysis. There is nothing wrong with the content of this sentence, and it's fairly typical of the kinds of sentences that law students turn in. But look at it. It's written in the passive voice, and it's really wordy. Now take a look at the sentence after we've edited it. Professor Maur's PowerPoint says that students can write more accessibly if they analyze their own work. The sentence on the left is a time waster, and it engenders a low level of frustration in the reader. I want you to think about that. Do you really want to frustrate your professors or any reader? If you write in the manner set out on the left-hand side of the page, your good ideas are quite likely to be lost. So, this is a rookie mistake. I'm going to read you this quote in its entirety because I believe it's a really important one. This is a quote from Professor Stephen Walt of Harvard University. He says, which leads me to the real reasons why academic writing is often bad. The first problem is that many academics, and especially younger ones, tend to confuse incomprehensibility with profundity. Okay, incomprehensibility gets confused with profundity. In other words, you think you sound smarter if you use big words. This is not true. This is actually something that we look for and that tends to suggest that you don't know what you're talking about. I've been a teacher of one thing or another since I was 12 years old, which was a very long time ago. As a young person, I taught swimming, campfire skills, how to use a cash register, and every subject in high school because I was the unofficial tutor at my high school for all the slackers. Eventually, I had 4 kids. As a mother, I taught everything from shoelace tying to bike riding and how to eat without ruining your clothes to how to study and how to manage difficult relationships. And now I've been a law professor for 12 years. Here is the most important thing I have figured out about legal writing. If you can't explain a concept to a reasonably intelligent child in language they comprehend, you don't understand it yourself. If you can explain a concept in simple terms, your work will write itself. If you can't, you will struggle mightily with legal writing. Next, on to learning how to synthesize and summarize legal ideas.